California Penal Code Section 288.7 is a statute which criminalizes substantial sexual contact with a minor who is 10 years old or younger. And substantial sexual contact is generally described as vaginal intercourse, anal intercourse, oral copulation, or digital penetration. It is punished with a life sentence. And depending on the conduct alleged, it can be a 25 to life sentence, or for slightly lesser conduct, it would be 15 to life. And these sentences would stack. So if there are two instances of substantial sexual contact, you could be looking at 50 to life, 75 to life for 3, and so on. The common defenses or issues raised in a 288.7 prosecution really revolve around the issue of false allegations. It is rare that the defense to a 288.7 allegation would revolve around the type of sexual contact with the minor. It is more common that the allegation is false, and the defense must raise the reasonable doubt in the jury's mind that the allegation is false. So what we are usually looking for is reasons why the minor would lie, indications that the minor has a history of lying, and we'll also focus on the character of the defendant to show that the defendant himself, the person who is alleged to have committed these acts, is not the type of person who would commit these acts. And that is information that the jury can take into account. One misconception in this type of prosecution is that there is always going to be physical evidence left behind after this type of sexual contact. What the prosecution's experts often try to show is that this type of penetration, or the penetration of a minor, does not always leave behind physical signs on the minor after the act is completed. Whether that's true or not is open to debate, and there are defense experts that can come in and attempt to refute that sort of testimony. But one thing the jury will hear is that it is not necessary to show that there are physical signs left behind on the minor. And so this is something that the defense often has to combat. It is very common for a minor raising these types of allegations to change their story over time in the various tellings, whether it's to their parents, to CPS or police investigators, or to the court during testimony, to the jury itself. And the prosecution will usually bring in a witness that will address the fact that child sexual assault alleged victims will change their story, and they will tell the jury that that is to be expected. This is through a mechanism known as the Child Sexual Assault Accommodation Syndrome. It's a misnomer. It's not actually a syndrome. But experts present it as if it's something that has been tried and tested, that alleged sexual assault victims will change their story, and that's okay. That they will recant, and that's okay. That they didn't disclose at the time of the alleged acts, and that's okay. The Child Sexual Assault Accommodation Syndrome expert will attempt to paint the prosecution's picture for them, which is that the child is to be believed at the time that they told the story of the alleged offense, and that anything that's happened to tend to disprove that should be disregarded. It is vital that the defense attorney is aware of the Child Sexual Assault Accommodation Syndrome, has familiarity with the ways to combat it, and has experience in dealing with these experts on the stand, because they can be devastating to a defense case. The defendant will often think, well, the minor who said this has now taken their story back, so the case is going to go away. The case is not going to go away. DAs are trained to believe that minors, that alleged victims, recant their stories on a regular basis. And while they are ready and willing to believe that the most horrific stories that come out of these minors' mouths are true, they are rarely ready and willing to believe the minors when they say that they were lying. One thing that it's important to help a jury understand is that in our everyday lives, we know that kids, they do lie and they do make up stories, and they do it for all sorts of reasons. And that can be lost in the seriousness of the allegations that are made that underlie this type of charge. It's important to bring the jury back to help them understand that it is their job to assess the credibility of every witness, even a witness who is claiming or has claimed to be a victim of this type of crime. No matter how horrendous the allegations are, it is still important that the jury understand that their job is to make the DA prove the case beyond a reasonable doubt. And if there is a reasonable doubt, no matter what the charges are, the defendant is entitled to an acquittal and must be found not guilty.